Good morning, Jack.
Morning, Bob.
I thought today we could talk about the administration's posture with the courts right now and the increasing evidence of court frustration and lack of trust in the administration, beginning with your posting recently about the extraordinary Supreme Court order on Saturday. Your thoughts then, as expressed in the posting, and any thoughts you've had since, and then we could talk about the issue more broadly.
Sure. This is something you and I have been talking about both in these video chats and in our writings about whether the Trump administration's really extraordinary disrespect and gamesmanship with the courts with respect to judicial orders, attacks on courts, whether, when, and how it would start to hurt them before the courts and especially the Supreme Court. And I think we got the first clear indication of that very early Saturday morning when the court issued this extraordinary order. Basically, it was an administrative stay, which is a stay of lower court proceedings, so the court could decide how to rule on an emergency application itself. It's like a keep things as they are while we decide. And the basic this was about Alien Enemy Act removals. You recall on April 7th, and I'll just be brief, that the court ruled that the Alien Enemy Act removal cases had to be brought in habeas, could not be brought under the Administrative Procedure Act. So you have all these individual habeas cases going on. The court also said that in that April 7th notice that that persons before being removed under the Alien Enemies Act had to be given adequate and reasonable notice so that they could file their habeas petitions. And so since then, there have been these habeas actions. And to make a long story short, it appeared as if the administration was about to engage in another round of Alien Enemy Act removals starting Friday or so, Thursday perhaps. And the ACLU basically started filing a bunch of emergency orders in the district court, the Court of Appeals, and ultimately the Supreme Court. I will spare us the really complicated legal details. The bottom line is the court issued this really extraordinary order. I'll just read it. The government is directed not to remove any member of the putative class of detainees from the United States until further order of the court. This was a putative class, i.e., they were trying to form a plaintiff class action of all potential Alien Enemy Act removal, people subject to removal. And the court just put a freeze on that. And Justice Alito filed a dissent, joined by Justice Thomas, in which he pointed out how unusual, let's just say how unusual what the court did was, and how there were some questions about it. It was very premature. There were some jurisdictional problems. But the bottom line, the point I've been trying to get to, is that it's clear that the court here believed that the government was not really taking seriously its order to provide reasonable notice. It's according to the ACLU, the government was basically giving the detainees notice in English only with a 24-hour period, which might not be enough time to get them lawyers. The government was not responding to the plaintiff's pleas about what's going on. And it just seems the best explanation for what the court did in this extraordinary order is that we don't trust you based on, this is my speculation, either all of your behavior since January 20th or your behavior with respect to the Alien Enemy Act matter. We don't trust you to comply with our orders or with judicial orders and to give due process. At least that was I think, the best explanation for what the court did in this kind of emergency temporary freeze of these proceedings. We'll see what the court does subsequently, but that's my take on what they did.
Let me ask you a question about Alito's dissent. You described it in your posting as fury. He's very unhappy with what the court did. What is your assessment of how he sees things? I mean, surely he recognizes the state of affairs, the factual state of affairs, the way the rest of the court does. It's hard to overlook it. And yet he seems to think that there are significant departures from practice and norms here in what the court did.
So, basically, Justice Alito's position is akin to the government's position, which is there are a lot of hard, tricky legal questions here about whether and how the court can act this early. I actually think it has the legal authority to act here this early as it did, especially in issuing an administrative stay. That would take me a long time to explain, and maybe I'll write about that one day. But the important point is there are lots of questions, jurisdictional questions, authorization questions about whether the court should have waited. I think the court acted appropriately. What Justice Alito is focusing on are the legal points, but he's missing the factual context. And just like the government basically in its papers really didn't address the concern, the real core substantive concern about whether it was providing due process. And Justice Alito did not address the core concern about whether the government was in fact providing due process to these detainees. And that is the core issue, whether the government can be trusted to do what the court earlier said it could do. And that's influencing all of these legal matters. Now, again, I want to emphasize, I don't think the court acted legally inappropriately at all. It was an administrative stay, but it was a very unusual order and it wasn't explained. So there are legal questions about it. But focusing on the legal issues, which is very important, misses part of the picture, which is the government's behavior.
And when you refer to the government's behavior, we're talking not just about their behavior, that is to say, in the treatment of the people subject to deportation, not providing the notice in a language they can understand, not providing the potentially with time they need to retain counsel. But you also note that the administration is making all sorts of other statements about the case, like Stephen Miller's comments on the White House lawn or statements made by the Attorney General. And that is something I assume that you also agree is going to influence how the court looks at the administration's good faith in this matter.
Yes, I mean, we don't know. But I mean, there are many levels here. The government has acted questionably in this case. In this case, since the court issued its original order, it's acted. That's just the government, the Justice Department in court, and the government in its treatment of detainees in general, in terms of movement and notice and things like that. Then there's the emanations coming from the Attorney General, Stephen Miller, the President, both with regard to this case and Abrego Garcia and immigration generally, and attacking the judges. And then there's the kind of more general attack on courts for getting in the way, unelected judges getting in the way of the elected president. So there are so many layers. And then there's the gamesmanship for in other cases, many other cases with regard to compliance with injunctions and candor before the court. So there are lots of layers going on with regard to the government's questionable behavior. No way to know, what level of this stuff is influencing the court, but I think it did in this case. Let me say something as a counterpoint. The court needs to be careful. And, Justice Alito's last line was, both the executive and the judiciary have an obligation to follow the law. The executive must proceed under the terms of our order, the April 7th order, and this court should follow established procedures. I agree with that. And I think the court did comply with established procedures here, but the court has to be super careful in being influenced by this bad behavior by Trump, that it, continues to make sure it crosses its T's and dots its I's. I'm sure it will. But anyway, that's the way I see things.
And yet it's probably pretty difficult, or the court's going to find it challenging to always dot the I's or cross the T's very precisely when it's under what we'd have to agree is just operating in extraordinary circumstances.
I mean, what the court was worried about was that the Trump administration was going to do to it what it basically did to Judge Boasberg in the original round of this stuff, which is try to get these folks out before any court could rule on it, despite the injunction or despite the court's order in place. And then, of course, the government would claim, well, I'm sorry, they're in the hands of another sovereign. We can't do anything about it. That is clearly the situation that the court is worried about. This is the situation identified by Judge Wilkinson in his two stay opinions in the Fourth Circuit in the Abrego Garcia case. I mean, this is clearly on the court's mind that the government is basically might be circumventing or giving minimal process to whisk people out of the country before courts can act, and then claim that courts don't have any power to do anything about it. And that is such an affront to judicial process and the rule of law that I think the court issued this extraordinary order to make sure it didn't happen, at least until it gets its hands around what's going on and what it should do next.
So let me move this for a moment to the domestic sphere and just note some other case that I think raises very similar issues in which a court basically said flatly the administration is thumbing its nose at us. And then talk a little bit and get your reaction to a suggestion about why the administration just continually puts itself into this space.
Yeah.
And there are a couple of theories, but let me just point out, in a district court decision that involves the administration's massive firings of employees at the Consumer Financial Protection Bureau, um, Judge Amy Berman Jackson decides or concludes that the administration has not complied with an order of the Court of Appeals that did not take any action on employee firing or termination without conducting individualized assessments of whether or not their continued services were necessary for the performance of the agency's duties. And the judge points out that almost immediately, the administration, in the guise of conducting individualized assessments, but with no apparent reason to believe that it had the time to do so, against affidavit evidence from other employees in the agency, it fired 1,400, issued notices of termination to 1,400 employees, and on the record appeared to reduce some of the offices within the CFPB to a level that made it, just on the sheer common sense of the matter, impossible for them to discharge their duties. And in that respect, she says, the administration was thumbing its nose at the courts. It was not doing what the Court of Appeals directed, but it was doing exactly what it was directed not to do, using the firings essentially as a means of shutting the agency down, of just eliminating it as a functioning operation. I mention this because there's been some talk about the administration over time slow walking and exhibiting a desire to make it hard for the judiciary to effectuate its intent in these orders. It seems to me we may be seeing an uptick in confrontation here. And here's the question I want to ask you. We've talked before about the lawyers in the administration and what they're faced with here, that they clearly are acting in a way that reduces the judiciary's trust in them and weakens the administration's chances of prevailing in its legal agenda. Maybe they don't care. That's one theory. The administration simply doesn't care and is going to gun for a confrontation and intensify it. The other possibility is, and I don't think it's inconsistent with the first, and this is the question I wanted to ask you, isn't Trump's politics, if you will, his basic politics here in the second term, locking him into this position? In the first term, his position was, as it was in his campaign for a second, as it was in his second term, I get stuff done. Nobody gets in my way. I am your voice. I can do what I want to save the country. No law can be violated if the purpose is to save the country. Now, of course, right off the bat, you have a fundamental rule of law problem there, but that's his position. In the first administration, he was constrained because he had an administration with people who didn't subscribe to that program across the board. In this administration, he picked people who do. And so he fundamentally is locked into the view that courts can't do this. They can't stop me. Congress can't stop me. Nobody can stop me. And that politics, if you want to look at it, that style of strongman presidential leadership guarantees that we are going to have potentially an intensifying conflict with the judiciary.
So I agree that that style of politics guarantees a continuing conflict with the judiciary. But I think it's been institutionalized, with the exception, as I mentioned in my piece yesterday in the Solicitor General's office, that style of politics is now being implemented, if you will, by the Justice Department. We don't know the exact mechanisms, but it's clear that the Attorney General, Pamela Bondi, is on board for this. It's pretty clear that Stephen Miller is having a huge influence on Justice Department positions, at least in the lower courts. So this confrontational style, yes, it's the president's. Yes, it was checked in his first term because he basically hired people both in the White House and in the Justice Department who were less MAGA, if you will, or less naturally confrontational, or more traditional conservatives. But I don't think it's a kind of byproduct of the politics. I think it's actually a part of the plan. It seems to be part of the plan, at least as being implemented by the Civil Division of the Justice Department in arguing these cases in the lower courts and in fighting with these judges down in the weeds about compliance and engaging in gamesmanship. I just don't think it's an accident. I think it's purposeful. What do you think?
I think it is inevitable I think you're right that they may think at this stage that they've won more than they've lost. I don't know whether that's going to turn out to be true or that they're going to recognize or come to see that it's true over the long term. I'm not sure about that. I think that they're going to run into some very strong headwinds, and I think that it could take a significant toll, for example, on his support among independents. That, in conjunction with adverse developments in the economy, I think are going to create the impression of an administration that is just out of control, preoccupied with his angers, his retributions, not focusing on what he was fundamentally elected to do in the social welfare, if you will, in rebuilding the economy or improving it, however you want to describe it. So I am less confident this is going to end well for them. They may rejoice in the short term and they may come to rue it in the long term.
I certainly didn't mean to suggest it's going to end well for them. But that raises the question, and we've talked about this for months now. What is the strategy exactly in this extraordinary confrontation with courts? The gamesmanship at the district court level, the attacks on courts throughout the administration, non-compliance or even gaming a little bit this Supreme Court order from April 7th in the Alien Enemies Act case. But it so obviously can't, well, let me say, it seems so obviously not to be going to help them in the Supreme Court ultimately, that one wonders what the theory is. I mean, maybe they think it will help them in the Supreme Court. I remember in one of the earliest things I wrote, Russ Vought said, you need to intimidate the Supreme Court. Just like Thomas Jefferson did with John Marshall in Marbury versus Madison. The reason that case was decided the way it was, where the court asserted judicial review but ultimately did not enjoin the executive branch to do anything, was, Vought said, because they were kind of intimidated that the executive branch wouldn't comply with the judicial order, so the court didn't issue the order, and Marshall flipped that and asserted judicial review and said, I don't have power to do it, but I have the power. I don't have the power to do it in this case, but I have the power. I mean, maybe that's the theory. Maybe the theory is that by being bullies, they can, basically bully the court into doing something and giving them victories that they wouldn't otherwise do. That's one rational approach. That's one at least approach I can understand. I don't obviously like it. Another one is they don't care what the courts say and they plan ultimately not to comply. I don't believe that will happen in the Supreme Court, but I don't know. But if it's not one of those two theories, either we don't plan to comply or we're trying to bully you into submission so that you'll give us favorable rulings. And I don't think either one of those are ultimately going to work, but I don't know. Other than that, it doesn't make any sense to me. It doesn't make any, I guess the third theory is it's good politics. Even if they ultimately lose more than they would have, they're really enjoying a great ride beating up on these unelected judges and blaming them for the nation's problems. So maybe that's the third theory, and they think that the political victories there outweigh the legal losses later. I don't know. What do you think?
That could well be. I have to say that when they start to bully the Fed and the market tanks, I think voters draw their own conclusions about these bullying strategies, and this is where I think they may be running up against the wall eventually in a way that's extraordinarily self-destructive, at least measured by their aims. But you're right. It's really hard to understand what they're doing. I also want to add something else, and I want to state it carefully. There does seem to me to be a lack of execution in this government. There's some real problems. I call it problems of governing competence that I think has also complicated the way it's going about doing things here, a kind of clumsiness and lack of attention to detail, inconsistency across various agency spokesperson talking on the same topic. And that I don't think helps them either. Okay, I think we can leave it there. Thanks a lot, Jack.
Thank you, Bob.